my name is Elizabeth Blandon. I'm an immigration attorney specializing in asylum law. This video in particular is about a procedure known as motion to reopen that hopefully will help you or someone you know get a green card through asylum. Now, asylum is basically protection given by the United States government to foreigners, only to those who are in the United States, regardless of how they arrived, whether they arrived through the airport with authorization or crossing a border without authorization. People can apply for asylum usually within the first year of arrival, which is very important. That's the 1-year deadline. But in some cases, they apply much later. The two general ways to apply are to file an application directly with immigration and request protection and request a work permit and a green card, or the other way to file is as a defense to being deported. So a person has been caught in the United States, they don't have authorization to stay here, and as a defense to not being removed to their home country, they say, if I'm removed to my home country, I'm going to suffer serious harm. In order to get asylum, the serious harm that a person fears suffering has to be on account of 5 protected grounds: race, religion, nationality, political opinion, or something called particular social group, which is explained in another video. This video discusses what about a person who had their case denied perhaps at immigration, or perhaps had their case denied at immigration court, and now they have an order of deportation in their hand. Well, incredibly enough, they can still apply for asylum based on something known as a motion to reopen. Now, a motion to reopen generally has to be filed within 90 days of that order of deportation. But there are some exceptions as to why it can be filed after the 90 days. I'll explain what those exceptions are, but generally they have to do with changed circumstances either of the country or of the person. In some cases, the ones that we win the most often or we see the most often are a person simply didn't know they had to go to court. If a foreigner does not appear in court when they're supposed to appear in court, a judge will issue an automatic order of deportation. It's known as an in absentia order of deportation. If the reason the foreign national was not at the hearing is because they never received a paper that said they had to go to the hearing, or what sometimes sadly happens, they hired an attorney and then the attorney didn't tell the foreign national that they had to go to the hearing. In both of those cases, or in other cases that are similar to that the foreigner didn't know, we can do a motion to reopen even after the 90 days, which is what's important. Other cases where it's been over 90 days and it's been approved is, for example, marrying a US citizen. That's a change in the person's personal circumstance. Perhaps before the order of deportation they weren't married, and now after the order of deportation they are married. There are immigration benefits for marrying a US citizen, and we might be able to do a motion to reopen based on that. In some cases, we specifically ask for asylum because the fact that the person is now married to a US citizen increases the risk that the foreign national, him or herself, will be harmed in their home country. In addition to that, there are other personal circumstances that might change. One that we see, for example, is persons from Muslim countries who might have converted to Christianity. For example, in some countries, such as the Islamic Republic of Iran, if a person changes from their religion to any other religion, they will be killed. It's a crime of capital punishment in Iran, so obviously a conversion to Christianity would result in death. Another similar kind of case is when a person perhaps had not come out before. They had been in the United States for several years, but only recently came out in public as, either lesbian, gay, questioning, bisexual, or transgender person. And now that they've come out publicly, they can't return to their home country because they might be harmed. And in some countries, serious harm or death might result. In those cases, likewise, it could be years after a person has an order of deportation. We can do a motion to reopen the case, file an asylum, and again, get the work permit, and hopefully get the green card if we win it. Little gold nugget that I also like to discuss, because it's not a program that's used very often, but it is very important. It's an important way of getting a green card, is for those people who have either temporary protected status, TPS, or deferred action for childhood arrivals, known as DACA. Those two programs give people work permit, but there's something more valuable that it gives them. They can also travel outside the United States with something known as advanced parole. If you leave the United States, and again, this is with an order of deportation we're talking, you leave the United States, you go to another country, and you return to the United States, when you return, you are now entering with authorization. One of the main reasons, in fact, the main reason some people can't get their green card in the United States, even though they might have children who are US citizens over 21 or spouses who are US citizens, one of the main reasons is because they entered legally. Well, if you enter with parole and you have an order of deportation, we can now reopen your case in court and get you the green card. That's something that's worth considering for many, many people. Also, one of the things that needs to be considered is changed country conditions. I always ask my clients to let me know what the situation is in their home country today versus what it was when they were ordered deported. Some countries in particular, Russia and the Ukraine, we have been able to win motions to reopen because the situation in those countries has seriously deteriorated, and we were able to prove it. It doesn't apply, however, in a case where the situation of the country was terrible at the time the person got the order of deportation, and it's only much more terrible. It has to be a very drastic change between then and now. So I also, when I'm stressing to people what cases might win, I also would like to stress what kinds of cases won't win. A case such as that where the condition of the country has worsened significantly, but it was terrible before also, you won't win that case. Also, if you're now more afraid because, say, you know somebody who died, there was a case where the death of a friend, the foreign national said, well, now I'm really afraid. I wasn't afraid before. I knew the situation in my country was bad, but it hadn't affected me personally until my friend was murdered. That also is not a reason to do a motion to reopen, because the situation in the country was bad when the person was ordered deported. Most importantly, if the reason you were given a deportation order is because you did not appear at the hearing, but you knew about the hearing, that is not a reason to do a motion to reopen. The only types of cases where a person will be given a second shot at the asylum apple is because they didn't appear the first time because they didn't know, whether through no fault of their own, is generally. The thing to remember about everything that has been spoken in this video is our job here with the Blandon Law team is to prove to the court that the totality of the circumstances, under all the circumstances that we're presenting to the court, it would be really unfair for a person who fears being harmed in their home country to have to return just because of one minor error. So if we can prove that, we can win the motion to reopen on your behalf and hopefully get you a green card. It's been a pleasure and good luck.